Gary Zimmerman is a lawyer with the McLennan Ross law firm out of Edmonton, Alberta. He discusses the effect social media sites like Facebook, Twitter, MySpace, etc. have on the insurance industry when it comes to litigation.
They call it user-generated content, and that content is actually mind-blowing if you look at the statistics out there. And it's social networking. What it allows is for people to connect with each other, of course, which is exactly what the word implies. But when people are connecting with each other, they're obviously posting information in somewhat of a public domain. And it's that information that they're posting that is often interesting to parties involved in litigation, all sorts of litigation. Not only insurance matters that relate to motor vehicle accidents where a plaintiff is putting their own health at issue, but just all sorts of litigation. And what you'll be able to find is that the police have started using social networking websites to track criminals that have evaded service for 2-3 years. Recently in Australia, an order was granted allowing a party to be served legal documents through Facebook. And right now what you have is you've got a number of different social networking sites, but the dominant one at the moment is definitely Facebook. Facebook has 200 million active users, they boast, and I've looked, that makes them the 5th largest country in the world. So it's actually pretty interesting. And then other ones that are dominant players are of course Twitter, but MySpace is there, and YouTube. And YouTube is truly amazing too, because there's 150,000 videos uploaded to YouTube daily. Now you can imagine if you're involved in personal injury litigation what that means, because when someone makes a claim, they put their health at issue. You don't have much to question their claims because their claims are often subjective. I'm in pain. And so one of the ways that we as defense counsel try to verify or refute their allegations is by hiring private investigators, and so we get surveillance on people, and it's very common to do that. But that's governed by a whole bunch of factors, one of which is expense, another of which is time, another of which is just being lucky to be in the right place at the right time. So what we've found now is that with things like Facebook, people are their own private investigators. They might not anticipate, but what happens is they get caught up in the whole business of fame, or whatever you want to call it, and they wind up posting photos of themselves or status updates. Some people, I think Facebook suggests that 20 million users update their status at least once a day. And that can mean anything from Gary Zimmerman bench pressed 250 pounds today, which you'll never see on my site, or Gary ran a marathon, or whatever the case is. And those are important, because if I'm defending an action and the guy tells me he can't bend over and tie his shoes, and at the same period of time that he tells me that under oath, I've got his Facebook account that would suggest that he's out there running marathons, it means a lot to me. And so that's changing the face of litigation, but we need a way to access that, because as you probably know, you can have your privacy settings on Facebook. Most people will have private accounts, meaning not everyone can go in and view that account. Some have open accounts, and in that instance, I as a defense counsel will type in their name, take a look, maybe I hit the jackpot, maybe I don't. Where they have made theirs private in Facebook, you'll need to be a friend, so to speak, to access that information. And that's not open to everyone, of course. And there's questions as to whether private investigators should make these people their friend for the purpose of investigating that. That hasn't gone to trial yet. I don't recommend it at this stage for various reasons, because it might make that information unusable at a trial, but that's a whole different issue. In any event, what happens is right now there's a move to make the documents producible. That is the Facebook account. And there's various ways that you can do that. One of which is the plaintiffs should, if they're putting their health in issue, should now voluntarily place the Facebook account, if they have one, and if it has pictures and status updates, etc., they should place that information into the record automatically through an affidavit of records in Alberta or whatever process in the other provinces. The other way that you can do that, in fact, beyond that, is through asking for the documents after. Hopefully they'll then voluntarily comply. You can bring an application to compel those documents. When you're at the discovery process, you can ask for those documents, and I'm calling them documents, but they're more properly termed records because it's a Facebook site. It's not truly a document. And then the other way you can do is, as I said, get a court order to compel a third party, and in this case Facebook or Twitter or whatever that organization is, to turn over their information that they have on their servers. And I got to tell you, this is a really new area of the law, and there haven't been, to my knowledge, unless it's been in the very recent past, any cases that have asked Facebook to turn over that information. Usually it's an application made against the plaintiff themselves to turn over the information. So it'll be neat to see where that goes. But in Florida, not too long ago, there was a decision handed down against MySpace, and it wasn't in a claim against MySpace, but what happened was the state of Florida brought an application to have MySpace provide all of their digital records in relation to Casey Anthony, and I don't know if that name rings any bells, but that's the lady that was indicted for killing her 2-year-old and then not actually disclosing it to anyone for months. The 2-year-old allegedly went missing, and it made a lot of media. And what happened was they brought an application, the state brought an application to have MySpace deliver all their records. They did, and through that, the state made their case that much stronger because she was in fact communicating with people through MySpace about going out and partying during the period that her child was allegedly missing and all of these other things. So it's pretty neat, and it's moving very quickly right now.